Good morning, everybody on the platform.
Morning, sir.
Good morning, sir.
Good morning, Chair.
Good morning, good morning. I think we are ready to start. Let me check. I'm told Babalwa still has some challenges. Nicolette, do we have a quorum? Nicolette.
And honorable members, I hope you are doing well. I will flag the agenda.
Okay, we do have a quorum. All right.
Oh yes, James. Apologies, we do have a quorum.
Okay. Let's see.
Recording in progress.
Let's see the agenda. Can you scroll it? There's the agenda. Can I get a mover for the adoption? Am I audible?
Sheikh Imam moves, Chairperson. Sheikh Imam.
Sheikh Imam moves. Boni, Honorable Marekwa.
Morning, Chair, and everybody on the platform. I do second. Thank you.
Thank you, Honorable Marekwa. Is there an alternative view? No alternative view. Therefore, this will be the agenda to guide our meetings. Can we have apologies?
Good morning, Chair. We received an apology from the Honourable Minister of Police. Ref Meshu indicated that he will join the meeting a bit late. And then, although Honourable Whitfield has joined the meeting, he indicated that he might have some connectivity issues. Thank you, Chair.
Thank you very much. Is Baba sorted?
Chair, unfortunately not yet. She's still struggling, but she will hopefully attend a bit later.
Okay. Thanks very much. We are now on item 3. Remarks by the Chair. Honorable Deputy Minister, honorable members, the Executive Director of IPIT, the Acting Secretary of Police, and all colleagues on the platform. Last week, South Africa hosted the 15th BRICS Summit in Sandton. The 3-day summit was attended by 40 heads of state, government representatives, local and international dignitaries, and delegates. Through the net joins led by the South African Police Service, South African National Defence Force, and the State Security Agency, the safety and security of all attendees were ensured. The committee extends its gratitude to the Executive, SAPS, members, SANDF soldiers, and members of the Johannesburg and Ekurhuleni Metro Police Services for their services during the summit. These members were disciplined and they were ambassadors not only for our country, but also for our security services. Honorable members, we noted not only for our country policy, but also for our security services. And Operation Chanela, members, we noted throughout only for our country policy. Operation Chanela is a crucial step in the right direction and shows that our police can adapt to emerging crime patterns. At a later date, the committee will invite the SAPS to share the many successes achieved through Operation Chanela. Deputy Minister, the committee extends its sincere condolences to the families of Sergeant Kidimeti Masilu and Constable Lukaetsi Mandindi, who were shot and killed while pursuing a suspect last weekend in the Northern Cape. This is a great loss to South Africa and the police service. We call on the Minister of Justice to ensure that the suspect is not released on bail again and that his sentence is not suspended again. We need to review the sentencing regime for persons who kill police members. The sharp rise in police killings is unacceptable and must be addressed with urgency. Honorable members, we extend a heartfelt welcome to Honorable Gomba, deployed to this committee by the ANC to replace the late Honorable Jumat Peterson. We also bid farewell to Honorable Khoza and thank him for his contributions to policing oversight during his time with the committee. Still on this one, we also thank Honorable Darabella, who was deployed here by the DA and now has been redeployed somewhere else. Honorable members, coming to the main order of business today, we will receive an introduction of the Independent Police Investigative Directorate, or IPID Amendment Bill, led by the Civilian Secretariat for Police Services. The State Law Advisor, Mr. Van Breda, will brief the committee on the constitutional certification of the amendment bill, followed by the Parliamentary Legal Advisor, Mr. Simani, who will brief the committee on the processing of the bill. The review of the IPID Act was identified as a priority of the committee at the start of the 6th Parliament in 2019. Since then, the committee was negatively affected by the significant undercapacitation of the Legal Service Division of the Secretariat for Police Service. This led to a decreased number of bills being introduced to Parliament. We were eager as a committee to review the SAPS Act, which did not materialize. We were also eager to review the IPID Act. The need for a comprehensive review stemmed from challenges on the operational and structural independence of the IPID. The tabling of the IPID Amendment Bill came late in our term, and we are here today to discuss the content, merit, and if need be, the desirability. I urge members to take note of the presentations made before us today and apply our minds to the further processing of the bill. My office has noted the concerns already expressed by Honorable Whitfield and Honorable Groenewald. I invite both of them to raise their concerns in this meeting today. Having said that, honorable members, Deputy Minister, We are now in your hands to introduce the bill to the committee. Honorable Deputy Minister.
Thank you, Chairperson of the committee. Good morning to you and to members of the committee. Thanks for the opportunity you have given us to present the IPED Amendment Bill to the committee for deliberations. I really appreciate the warm words you had for the work that was done by the NAT Joint over the BRICS Summit. I fully agree with you that it was a resounding success. It was good for the country, the continent, and the world that we could have such a successful summit, which will contribute to the development of humanity. We commend SAPS for the good work done together with the security forces that constitute the NAT Joint. We also appreciate your words of condolences to the officers who passed on duty and generally police officers who pass on duty, and that justice should prevail. And those who perpetuate this kind of acts must be given steep sentences. We fully support that, and your words of condolences are accepted warmly and appreciated. We will definitely take on board the management of SAPS and the minister in this regard, so that the committee appreciate the work done and also passes his condolences. With regard to the bill, Chair, I fully agree it is long overdue, but however, it's good that today we are before you. We have submitted our presentations, and we are alive to the challenges that were raised around Clause 4, which we believe that in the course of deliberations through the processes of the bill, the product that will come out of this engagement, we will have that particular section of the clause affected. We could have submitted a revised bill, but we thought it will not be appropriate for us to do that at this stage, because it was going to delay the processes that we are supposed to deal with today onwards around the bill. And we are of the firm view that we can still, in the context of this engagement with yourselves, be able to address that particular clause so that it is in line with the expectations and the legal views that we received in the course of the formulation of this bill, including an independent expert that we acquired to further consolidate. But the information from that side, when it came, we had already made the submission, so we couldn't affect the changes. So I just say, Chair, we are mindful of those challenges that are there, but we are confident that led by yourself and the esteemed members of the committee and the input from the public, we should be able to come up with a product that it will not be challengeable in court, and will be able to stand a constitutional muster in that regard. With those few words, if you may allow, Chair, we are joined here by the Executive Director of IPED, Mentratsing, and her team, but we also will be led through the presentation by the Acting Secretary, Mr. Amaru, and the Legal Division of the department, if you allow me, I will request that we allow the acting secretary and the team to take us through the processes, Chair, through you.
Thank you, DM. Mr. Amaru.
Good morning, Chairperson, DM, and honorable members of the committee, and Executive Director and colleagues. We will request Advocate Don Bell to lead the presentation through you, Chairperson.
Thank you, Advocate.
Good morning, Chairperson. Good morning, Deputy Minister and all honorable members on the platform, colleagues that are there as well. Good morning to everyone. I'm just going to go straight into the presentation. If we can give my colleague Hulisani rights to display, please, Chair, that will assist.
Nicolette, can you assist? Can you give Hulisani co-hosting rights?
Thank you, Chair.
Nicolette, are you assisting?
Apologies,
He has the
Tree.
right.
Sutu?
He has the right. Simani.
Hulisani
Mulisani.
Mashavele. Hulisani.
Hulisani, may you please assist, because you have the right. Secretary?
Morning, DM. He hasn't the rights as yet.
Sorry,
In future, let's deal with this logistics beforehand, because now we're delaying the meeting. In future, Secretary, let's deal with logistics beforehand. If there's a need for requesting a co-hosting rights, let's do it. Are you succeeding, Sutu?
Honorable Seabi?
Yes, Nicola?
If I may, would it be okay if I share the presentation?
Awesome.
Yes, it will also assist, because we're now wasting time. Please share it so that we continue as they are trying to resolve the other issues.
Thank you for your intervention, Chair. May I proceed?
Please proceed.
Thank you, Chair. If we can turn to slide 2 briefly, this just the overview of the presentation, which will be the summary, the background and the summary. If we can go to slide 3 now, please. On the background. So the bill was published for public comment on the 28th of October 2022, and the closing date for the submission of public comments was the 15th of January 2023. If I can just pause there quickly, Chair, just to state that the closing date was actually in December, but because there were so few comments received, about 2 or 3, we requested Minister to allow us to extend it for a further month. That's why it only closed on the 15th of January 2023. And thereafter, we received about 16 comments, and the list of the comments that were received are there. If you'd like me to go through it, otherwise I'll just skip it and go on to the next bullet point. The version of the bill that was approved by Cabinet takes into account these public comments that were received on the bill, and the explanatory summary, as well as the bill and the objects memo, is also published on the website of the department. Slide 4, please. So we move on to the summary of the bill now, Chair, and we'll start off with clause 1, which deals with definitions. And clause 1 of the bill seeks to amend section 1 of the Act through the insertion of certain necessary definitions that were not included, Chair, in the Principal Act, or those that came about as a result of amended clauses. These were also considered. These, for example, are the definition of firearm, municipal manager, and executive head of the municipal police service. These are among those definitions that have now been included. Then clause 2 deals with the establishment of the Directorate, and it amends section 3 of the Act, and it provides that the Act must exercise, the Directorate must exercise its functions in accordance with the Constitution. Clause 3 deals with the independence and impartiality, and it seeks to amend clause 4 of the Act and provides that the Directorate is institutionally and operationally independent. And this means that it acts without fear, favor, or prejudice, or undue favor. This proposed amendment gives effect to the Constitutional Court judgment in the McBride matter. Then we come to the next slide, on slide 5, and this is the one, Chair, that the controversial clause 4. And what I'm going to read out now is as it was introduced in Parliament, but as our Deputy Minister mentioned, that we have revisited this clause on the advice of the state law advisors and the expert opinion that we received recently. So as it reads now, it provides amendments to section 6 of the Principal Act. It also provides for the appointment by the minister with concurrence of Cabinet for a suitable person as the Executive Director of IPID for a non-renewable period of not less than 7 years, but not longer than 10 years. So the minister also tables a notice to Parliament on the appointment of the Executive Director within 14 days of the appointment. So I won't dwell on this one here, safe to say that it has been reviewed, and there is a position that is aligned with the McBride judgment and the Constitution that has been prepared by the drafting team. So if we can go to the next slide, please. Sorry, let's stay there with clause 5. This deals with the responsibilities of the Executive Director, and it amends section 5 of the Act to ensure that complaints regarding disciplinary matters involving certain provincial and national executives are referred to all appropriate authorities, which now also includes the municipal manager and the executive head of the municipal police service. Next slide, please. So this clause further provides that the ED can initiate an investigation once he or she becomes aware of a complaint against a SEPS or a municipal police service member, and not only when a complaint is referred to him or her. In clause 6 deals with the composition of the national office, and this clause proposes the deletion of section 8(1) of the Act, which deals with the composition of the National Office of IPID, as it is a matter that could be dealt with through IPID's internal policies and procedures. It also amends how and by whom the pre-employment security screening investigation should be conducted. And this security screening deals with the criminal and credit checks that can be conducted internally by IPID. Next slide, please. The next slide, Chair, deals with clause 7, which deals with the functions of the National Office. It amends Section 9 of the Act, which provides for the identification and review of legislative needs in consultation with the Secretariat and reported to the Minister and not to the Secretary as provided for in the Principal Act. Then clause 8 deals with delegations. It amends Section 3 of subsection 3 of Section 10 of the Act through the deletion of reference to Section 7 sub 9, which empowers the Executive Director to delegate the initiation of investigations of any offence allegedly committed by SAPS or the MPS member to the provincial heads of the Directorate. Next slide, please. The next slide has clause 9 on it, which deals with the composition of the forum. And it seeks to amend Section 16 of the Act through providing that a person, a representative from a government department or institution may be invited to a meeting of the forum if a particular matter concerns such person, government department, or institution. And this, Chair, allows the forum to engage with persons or institutions on matters which concerns the carrying out of the forum's duties and powers. Then clause 10 deals with the provincial officers, and this clause actually repeals Section 19 of the Act, which sets out the salary levels of the provincial heads of IPID, as this is considered not necessary to provide for such matters in an Act. Next slide, please. Clause 11, Chair, deals with the responsibilities of provincial heads, and this clause deletes paragraph M of subsection 1 of Section 21 of the Act, which provides for the preparation of the financial statements by provincial heads of IPID, as in practice, such statements are prepared only by the National Office. Therefore, it is not a function or responsible of the provincial office, Chair. Clause 12 deals with the appointment of investigators. It provides for amendments to Section 22 of the Act by the deletion of reference to the qualifications for the appointment as investigator, as it is not necessary also to provide for such in the Act. Next slide, please. Chair, I turn now to clause 13, which deals with the remuneration and conditions of service of investigators. So clause 13 amends Section 23 of the Act. It provides that the conditions of service, including salary and allowances payable to investigators, shall be determined by the Minister in consultation with the Minister responsible for finance. Clause 14 deals with the functions and investigation powers of the investigators, and it provides for insertion of paragraph B capital A in subsection 2 of Section 24 of the Act in order to bestow upon IPID investigators the powers to take buccal samples, and this, Chair, aligns it to related provisions in terms of the South African Police Service Act 68 of 1995. Next slide, thank you. Chair, this clause further provides for the insertion of paragraphs 6, 7, 8, 9, 10, and 11 of this section of the Act to strengthen procedural matters, Chair, regarding the subpoena of persons for conducting an investigation to prevent the disclosure.
Hey, so sit close your mic.
Tuso. Continue, Advocate.
Thank you, Chair. Thank you, Chair. So, Chair, this proposal strengthens the procedural matters regarding the subpoena of persons for conducting an investigation to prevent the disclosure of the contents of documents, records, or the contents of any interview or questioning given under oath to an investigator. Clause 15, Chair, deals with the limitation of liability, and it proposes the insertion of subsection 2 into section 27 of the Act, which provides for limitation of liability of officials of the Directorate. And Chair, this is for information reflected in a report, a finding, point of view, a recommendation given in good faith and without gross negligence in performing a function in terms of the Act or any other relevant authority. Clause 16, Chair, deals with the types of matters to be investigated. Here, this proposal seeks to amend subsection 1 of section 28 of the Principal Act in order to provide that the Directorate shall investigate the crimes of rape and murder, whether they have been committed on or off duty. Chair, if I may just pause here for a bit, this section, in the current Act has recently come under microscope, and we are of the view that the new proposals will assist IPID investigators in executing their work, as well as the SAPS and the Metro Police on how to go about their duties without falling foul of the law. So if we carry on the next slide here, just to mention a few amendments. So paragraph C, the complaint of a discharge of an official firearm by any police officer is repealed. And paragraph F provides that IPID shall investigate the investigations of assault only if it is committed with the intention to cause grievous bodily harm. Then paragraph G, the referral of corruption matters by the National Commissioner or the appropriate provincial commissioner, national head, or the appropriate provincial head of the Directorate for Priority Crime Investigation, the executive head of the relevant municipal police service, and the municipal manager. Then attempted murder in relation to the discharge of an official firearm has been inserted as a new paragraph G capital A of the bill. So this is also any complaint or the deletion thereof. We can debate that later on in the consultations. Clause 17 is reporting obligations and cooperation by members. And this is also as a result of the public comments. Proposed amendments to section 29 of the Act provide for the referral by the station commander or any SAPS member and the municipal manager of matters for investigation by the Directorate. And this is also immediately after they become aware thereof. So they shouldn't wait for IPID to find out about it. If they know about it, then they can report it to IPID for further investigation. Next slide, please. Okay, so if we just can go on to clause 18, the disciplinary recommendations. Clause 18 seeks to amend section 30 of the Principal Act in order to strengthen the provisions relating to the implementation of disciplinary recommendations of IPID, as well as to specify whether the disciplinary recommendations of the Directorate were implemented and the extent of the implementation thereof. Chair, this would ensure that IPID's disciplinary recommendations are not only implemented, but IPID is informed of the reasons its recommendations are not implemented. Clause 19 deals with the finances and accountability, and this clause amends section 31 and proposes that the Directorate shall also be accountable to both the Minister as well as to Parliament. Next slide, please. Clause 20, next slide, please. Okay, so clause 20 deals with regulations. Amendments to section 34 of the Act provides for new matters which the Minister may make regulations on. And this was also brought about by proposed amendments to the Act. Then clause 21 deals with the savings clause that provides for the substitution of section 35 of the Principal Act as the transitional arrangements provided therein have been fully implemented. The saving clause will ensure that the conditions of service, including the remuneration and other benefits payable to employees of the Directorate before the commencement of the IPID Amendment Act 2023, and may not be less favorable upon the commencement of the Act. Next slide, please. Clause 22 deals with the arrangements of the sections, and it provides for the substitution of headings of certain sections of the Act. And clause 23 deals with the short title and commencement, which provides for the determination of the date on which the Act shall come into operation by the President by means of proclamation in the Government Gazette. And that brings me to the close of this presentation. Thank you, Chair.
Thank you very much, Advocate. Secretary, are you fine?
Thanks, Chairperson.
Okay. DM, are you fine?
Thank you, Chair. I think that should be okay. Let's allow members to interact with the presentation. Thank you very much for the opportunity once more.
Thank you, DM. Can I allow our colleagues from the state law advisors to present?
Good morning, Chair. May I share my screen?
Yes, please. Can we assist? All right.
Thank you, Chair. Is my screen visible? The opinion.
Yes.
Thank you, Chair. Morning, Chair and honourable members. I'm Mr. Van Breda from the Chief State Law Advisor's Office, and thank you, Chair, for inviting me to present this opinion. Chair, this legal opinion was prepared in accordance with Rule 279, Sub-Rule 3 of the National Assembly Rules, and was submitted to the Speaker of the National Assembly on the 3rd of July of this year. Now, I'd like to refer you, Chair, to Rule 279 of the NA Rules, which governs the introduction of bills in the National Assembly. And Chair, in terms of Sub-Rule 2, a bill introduced by a cabinet member or deputy minister must be certified by the Chief State Law Advisor or a state law advisor designated by him or her as being consistent with the Constitution and properly drafted in a form and style which conforms to legislative practice. In terms of Sub-Rule 3, if a bill is not certified as contemplated in Sub-Rule 2, the bill must be accompanied by a report or legal opinion by a state law advisor mentioned in Sub-Rule 2 on why it has not been so certified. Chair, our office, as you must have gathered from the opinion, our office was not prepared to certify that the IPID Amendment Bill is consistent with the Constitution and in the form and style which conforms to legislative practice. Now, this legal opinion was therefore prepared in terms of Rule 279(3), which provides the reasons for our office not having certified the bill in terms of Rule 279(2), and was subsequently submitted to the Speaker of the National Assembly. Chair, I will now discuss the rationale for our office not certifying the bill. Now, Clause 4 of the bill proposes amendments to Section 6 of the IPID Act. And that section provides for the appointment and the removal of the Executive Director of IPID. Now, in terms of Section 6 of the IPID Act, Chair, the Minister must nominate a suitably qualified person for appointment as the Executive Director of IPID, and the section further provides that the nomination made by the Minister must be confirmed or rejected by the relevant parliamentary committee. Now, Chair, our concern with Clause 4 of the bill is that it provides for the exclusion of Parliament from the appointment process of the Executive Director and proposes that Parliament will merely be informed of the appointment. Now, the independence of IPID is required in terms of Section 206, subsection 6 of the Constitution, which provides that an independent police complaints body established by national legislation must investigate any alleged misconduct or offense committed by a member of the police service. Now, in the Constitutional Court judgment of McBride versus Minister of Police and another, the independence of IPID was considered, and the constitutionality of certain provisions of the IPID Act was challenged, including Section 6, subsection 6 of the Act, which provides for the removal of the Executive Director without parliamentary oversight. Now, it must be noted by the committee that the constitutionality of subsections 1 and 2 of Section 6 of the IPID Act was not challenged, as it currently does provide for parliamentary oversight in respect of the appointment of the Executive Director. Now, the Constitutional Court in that judgment declared certain provisions of the IPID Act as unconstitutional, including Section 6.6, due to the provision empowering the Minister to remove the Executive Director from office with no parliamentary oversight. Now, in accordance with the Constitutional Court's order, Parliament passed the IPID Amendment Act of 2019, which remedies the unconstitutional provisions of the IPID Act and further provides for the removal of the Executive Director subject to parliamentary oversight. It must, however, be noted that the IPID Amendment Act of 2019 is not yet in operation. Now, in the McBride judgment, the Constitutional Court held that the meaning of the independence of IPID necessitates a careful examination of a wide range of factors, including the method of appointment of the Executive Director, the method of reporting, disciplinary proceedings, and the method of the removal of the Executive Director from office. Now, the court also made reference to the Constitutional Court of judgment of Glenister versus the President of the Republic of South Africa and others, which concerned the independence of the Directorate for Priority Crime Investigation, and the court in that matter cited and approved the following definition of independence in respect of anti-corruption bodies from a report prepared by the Organization for Economic Cooperation and Development, which provides that the independence primarily means that the anti-corruption bodies should be shielded from undue political interference, and that experience suggests that it is the structural and operational autonomy that is important, along with a clear legal basis and mandate for the special body, department, or unit. This is particularly important for law enforcement bodies. Transparent procedures for appointment and removal of the director, together with proper human resources management and internal controls, are important elements to prevent undue interference. Now, the court in the McBride judgment, Chair, found that definition of independence is useful and illuminating in trying to define the independence of IPID, and further held that in contradistinction to the Directorate for Priority Crime Investigation, the threshold for satisfying IPID's independence is in fact more stringent, considering that the Constitution expressly demands its independence. And the court further held that provided the minister with excessive political power and control over the appointment and removal of the executive director is in conflict with the entrenched independence of IPID, and held that this may result in the minister invoking political influence to appoint a person as executive director, which may lead to IPID becoming politicized and being manipulated, and that this would be in conflict with IPID's constitutional independence. Now, in addition, Chair, the court held that the method for the appointment and removal of the executive director is essential in determining IPID's independence. And it is therefore our legal opinion, Chair, that the method for the appointment and removal of the executive director is essential in determining IPID's independence. And the removal of IPID from the appointment process for the, the removal of IPID from the appointment process for the executive director will prejudice the independence of IPID as required in terms of the Constitution. And the absence of a transparent appointment process will not pass constitutional muster. Thank you, Chair. That concludes the presentation.
Thank you very much. Can we quickly receive a presentation from the Parliamentary Legal Office?
Good morning, Chair, and good morning, members. Thank you, Chair, for inviting us to this meeting. With me, I have Mr. Siviwe Njigelan. He's also our colleague in the Legal Services Department of Parliament. Our office was requested to provide an opinion on the to the Portfolio Committee on the process that it may follow in dealing with the IPID Amendment Bill. In light of the fact, as per the previous presentation, that the bill was not certified in terms of Rule 279, Rule 2 of the NA rules. And we were also advised that subsequent to that, there was an opinion that was provided in terms of 279 sub-rule 3 of the NA rules, which effectively provided the reasons why the bill was not certified. In light of that, we were then requested to provide an opinion on how the committee should proceed in processing the bill in light of these unique circumstances where the bill is not certified as constitutional by the Office of the State Law Advisor. In terms of our reference to legal framework, we referred to Rule 284, Sub-Rule 4, which provides the process that has to be followed when the bill is introduced during the recess period.
Simani, sorry, Mr. Simani, are you yes, not flighting something?
Oh, sorry. Let me see if I can get it. Just give me 1 second. Sorry, Mr. Chair. Just give 1 second.
Good morning, Chair. If I may, I'm able to flight the opinion.
Okay. Are you fine with that?
Oh, I've got it, sir. I'll see if I can flight it. I've just got it here. Just give me 1 second.
Okay, let's flight it for the convenience of
Oh, yes,
those who are
please.
in the meeting.
Yeah. Mr. Chair, are you able to see the presentation?
No.
Or perhaps let me rather ask Nicolette to assist.
Please assist Nicolette. There you are.
Yeah.
Yes.
Okay,
You can just...
thank you. Oh yeah, thank you, Mr. Chair. As I was saying, we refer then to NA Rule 284, which makes a provision that has to be followed to when the bill is introduced during the recess period, which states that if the bill is referred to an assembly committee, the committee must deal with the bill in accordance with the Rule 286. But if the bill is referred to the joint committee rules apply. Now, the relevant part is then will be the Rule 286 of the National Assembly Rules, which sets out the process that has to be followed, which states that after due deliberation, the committee must consider a motion of desirability on the subject matter of the bill. And if rejected, must immediately table the bill and its report on the bill. Sorry. If the motion of desirability is adopted, it must proceed to deliberate on the details of the legislation. It may also recommend approval or rejection of the bill or present with its report on amended bill or redraft of the bill, provided that in the case of a redraft, the subject matter of the bill has not been extended without the permission of the Assembly as contemplated in paragraphs B and C. Now, NA Rule 286C is actually setting out the different stages that the committee must follow in inquiring into the bill. That is sub-rule 286C. 86C states that in the process of inquiring into the bill, the committee must, where applicable as far as possible, apply the following separate formal stages. The first one will be the informal discussions on the principles and subjects of the bill, including the briefing by the department concerned, and in the case of a member's bill, by the member of member consent. But in this instance, this is an executive bill, then it means then the department has already done so in terms of briefing the committee. Further to that, the consideration of public comments that have been received to date. And after that, then there are motion of adoption of a motion of desirability relating to whether the principles of the bill and the need of the bill are accepted. Invitation for public comment and submission. In other words, to invite public comment only happens after the committee has adopted the motion of desirability on the bill. To circumvent a situation where the parliament may incur wasted cost, whereby it will invite further comments when in fact there is no decision as yet in the fact that whether the bill has been adopted, the motion of desirability has been adopted or not. In this case, it looks like 286 is setting out these steps in a sequential manner that the committee has to follow them when it's inquiring into the bill. And the deliberation by members taking into consideration the proposed amendments and comments and proposed proposal received and evidence presented. Then the next step will be the formal consideration of the bill clause by clause, including amendments as formally proposed. And the last step, the consideration and adoption of the committee's report and adoption of the final version of the bill as it is presented to the National Assembly. These are all the stages that are set out in Rule 286, Sub-Rule C, 6 rather, of the NA rules. Now, NA Rule 286, Sub-Rule C provides that the committee, where applicable, must adopt a motion of desirability relating to whether the principles of the bill and the need for the bill are accepted. Then if we zoom into Sub-Rule 286, Sub-Rule C of the NA rules directs the committee to publish an invitation for further public comment and submission on the substance of the bill, followed by the hearing and examination of such or other oral submission if deemed necessary. The Constitution, in terms of Section 44, vests the legislative authority with the National Assembly. The NA rules set out the processes in terms of which the committee may amend a bill referred to it. In other words, the National Assembly is vested with the legislative authority in terms of Section 44, subsection 1 of the Constitution. The certification of the bill by the Office of the Chief State Law Advisor is a procedural requirement in terms of Section 279, of NA Rules 279. However, the lack of certification of the IPID amendment and the opinion provided are not binding on the National Assembly because of, in terms of Section 44, subsection 4 of the Constitution, the National Assembly in its legislative exercise is bound only by the Constitution. Be that as it may, the opinion that is provided by the Office of the State Law Advisor must be considered by the committee during its deliberations of the bill. Now, the options are available to the committee in processing the bill are either to adopt or reject a motion of desirability on the bill. If the motion of desirability is adopted, then the committee must proceed with its public participation process. That is, invite the members of the public for further public comments. Thereafter, the committee must deliberate on the bill, considering the public submission evidence, which also includes legal opinions it may have received on the bill, and amendments proposed by the members of the committee. It is therefore during this stage that the committee must also consider the constitutionality of clause 4, which was highlighted in the opinion that was provided by the Office of the State Law Advisor. The committee may then formally adopt any amendments to the bill it has agreed to, and thereafter adopt the bill with or without the amendments. In conclusion, Chairperson, in view of the above facts and discussion, the NA rules undoubtedly permit the committee to make these amendments. We'll therefore advise the committee to invite comments on any subsequent amendments that may materially or substantially change the content of the bill. Thank you, Mr. Chairperson. That concludes our presentation.
Thank you very much. Honorable members, I think now we have the presentations, and it is up to the committee members to chart a way forward. And as we make our inputs, please remember that as this committee, we had commitment to continue processing the bill. Please note that the Office of the State Law Advisor did not certify the bill, but also note the input by the Deputy Minister with regard to the constitutionality of the bill and the desirability of the bill. Honorable Whitfield.
Thank you very much, Chairperson, for the opportunity, and thank you to all of the presenters, the Civilian Secretariat, the Office of the Chief State Law Advisor, and the Parliamentary legal team. Chairperson, I believe the committee is presented with a hinge of history moment, if I may call it that, and an opportunity to really provide leadership in terms of holding the executive to account. There are a number of issues here which may be considered procedurally flawed. There is certainly the issue of constitutionality, and we must also recognize the fact that this is one of the bills that was prioritized in 2019-20 already, and it has now been left to the last few months of the 6th Parliament for Parliament to deal with. And all of these factors have to be considered so that Parliament plays its role in ensuring accountability and transparency, that we promote the constitutionally enshrined principle of independence, which is listed in section 2066 of the Constitution, specifies independence as set out by the Chief State Law Advisor, and that we appreciate that Parliament has a particular responsibility in the processing of this legislation to consider whether this is a desirable or undesirable bill, and the implications thereof in terms of incurring wasteful costs of embarking on costly public participation on a bill that we now know has not been certified and which has certain serious constitutional question marks around it. I'm not going to go into the presentation by the Civilian Secretariat, but suffice it to say that it is my understanding that the original bill that was gazetted from Cabinet last year did make provision for Parliament in the appointment process. It was then amended to remove that and to expressly exclude Parliament. In fact, I would say that the presentation from the Civilian Secretariat Chair was somewhat misleading to say that Parliament has a role. Parliament's role in that presentation and in the amendment bill is at the end of the process, and it's only by serving a notice or tabling a notice in Parliament. And that is completely insufficient and inadequate. It is simply not acceptable. In fact, I would go further to say that the provision in the existing Act which makes provision for Parliament is not even strong enough, that the process of appointment should in fact originate outside of the purview and authority of the Minister, and that the Minister is the port of last call, not the port of first call. We need increased independence over the entire process so that we can prevent political interference and strengthen the independence of IPID. And I think that our focus, Chair, should really be on that concept of independence. And I think that the Glenister judgment sets out quite succinctly and perfectly what the interpretation of independence is insofar as IPID is concerned and other similar institutions of the state according to the Constitutional Court. So, Chairperson, the only question that I have, and I think it's clear which way I'm leaning, and I'm prepared to deal with that motion of desirability if that is what we are here to deal with today. But the Parliamentary Legal Advisor indicated that the committee should consider public comments. I'm not aware that those public comments that were generated from the first round of public participation last year, I'm not aware that those have been sent to us. Could that just be clarified? And I apologize if I have overlooked that, but I would imagine that we would need to consider those according to, I think what was it, section 286 of the rules, that we make sure that we observe the rules to the letter, and that if we are required to consider those public comments, that we do so before we consider the motion of desirability, and that potentially be postponed until we receive those public comments. So if I can get clarity on those public comments, and then if my sentiments surrounding the presentations and my views on this matter be noted. Thank you very much, Chair.
Thank you, Mr. Whitford. Because we are dealing with the bill, I'm not sure where the question is directed, maybe to the Secretariat or the parliamentary advisors. Can we answer that question on public comments before I recognize Honorable Groenewald. Is it a Secretariat or Parliamentary? Yes, hello.
Chair, apologies, I missed it quickly.
The question from Honorable Whitfield, it's the public comments that were submitted to the department. Have they been sent to the committee? Is there a need to send them to the committee before we move on?
Chair, apologies. Ordinarily, we do not consider the public comments that was made to the department as such. However, it is good for us to see how the original public comments were incorporated by the department. So we could request the department to share those with the committee. Thank you, Chair.
Honorable Groenewald.
Thank you, Chair. Good morning to everyone. Chair, I'm going to take my face off the screen, but I will be here. Firstly, from my side, I think we must say to each other, Honourable Chair, that we must think very carefully. And when I say that, I mean that we as a committee, if we make a decision, we must understand that we must take responsibility for that specific decision. And we must also understand that this bill is a very important bill, and there is quite a lot of public interest in this specific bill. We must remember there were quite a number of institutions that commented on the bill as far as the department is concerned. Now, as we heard, we as members didn't receive those inputs. But that is why we have a specific process that when we adopt, for instance, the desirability, then of course we will have to publicize and get the reports and the comments from the public. Now, Chairperson, you know, in Afrikaans we have a saying. It says, 'n haastige hond verbrand sy mond. What I mean by that is that we must ensure, and we must look a bit back into history. Why are we here today? And why do we have the situation where we have an amendment bill in front of us? Now, we all know it originates from the Scorpions. In 2007, a decision was taken to abandon the Scorpions, and that's where we get into this IPID situation. And over the years, we had different views, we had different processes, different, can I say, court cases, because of the most important matter of independence. Now, Chairperson, and I'm not going into the presentation from the Secretariat at this moment, the clauses referred to. The fact of the matter is that we must remember that institutions and the public, the moment we do not comply to the correct procedural matters or any other matter, They will take us to court, and we know there are a couple of court cases where it was put very clearly that, for instance, public participation is essential, but we must also understand that procedural matters are also of the utmost importance. And those procedures are not there just to say, well, let's get direction of a specific bill. The procedures are there to ensure that there is compliance, for instance, to the whole process. Now, what is most important, Chairperson, in this specific situation which we reserved this morning? From the offices of the State Law Advisors, they refer to Rule 279, 2 and 3 and 4. The matter of the fact, puts it quite clearly. The procedure, National Assembly's procedures determine that there must, and I want to put emphasis on the word must, there must be approval from the Office of the State Law Advisors. Then we can come to the rule, what was it, 286, or 28, what was that rule, referred by the Parliamentary, Rule 286 from the Parliamentary Advisors. We must remember 279 is before 286. Now, there was not compliance to that. And I want to say, Chairperson, that if we continue, well, we must take a decision on the desirability or not. I can guarantee you, these institutions, they will take the matter further and said that you didn't follow your own correct procedures to get to this situation. We should, in fact, get an explanation from the department why the original bill was changed to what we have now, and which is quite controversial at the moment. So, Chairperson, having said that, we must also bear in mind, by the end of this week, we're in September. We must also look at the program of Parliament. We're going in recess the 1st of December. Even if we continue, there must be ample time for the public and for public inputs. We know that from now till December, there are still certain breaks. And Chairperson, then we must also understand that we are having an election next year. And those members who've been in Parliament a long time know that when it comes to an election year, the activities in Parliament is actually much less because you have to focus on the election. And I'm worried, Chairperson, that we're going to have a time frame constraints. We are going, like I said, haastige hond verbrand sy mond. We are trying to push it, and we're going to make mistakes. And in the end, we end up in court again. And if we are of being told beforehand to say that procedurally you didn't follow the correct procedures, there must be approval from the Office of the State Law Advisor. Then we put our integrity as lawmakers, because we make the law, then we put it under constraint. And I, as a member of this committee, feel that that is not the correct way to go. And bearing that in mind, Chairperson, I will appeal to the committee to think very carefully for the approval of the desirability at this moment. And remember, yes, we all agree we must get an amended bill. That's true. That is desirable. But remember, desirability actually has two parts. The desire to have such a piece of legislation, but the other aspect of the principles. And part of the principles is to ensure that we follow the correct procedures. So that is from my side and my input. Thank you very much, Chairperson.
Thank you, Honorable Groenewald. Honorable Whitfield, is that a legacy hand or a new one?
It's just a quick follow-up, if I may, Chair.
Okay. You are on the floor.
Thank you very much. Chairperson, my request for the public comments is really just so that we circumvent the process. If any members feel that this bill is desirable, I think we can prove based on the facts and the evidence that's been presented that it is not a desirable bill and that the motion should reasonably and rationally be rejected. But if there are any concerns, then, surely then members could be furnished with those public comments. And the reason I say that is because, as Honourable Groenewald raised, we need an explanation as to why the bill, from its original draft, certainly from the Act in Section 6, was changed with the introduction of Clause 4. We heard from Advocate Dawn Bell that this was on the basis of advice from the state law advisor. We now know that that's not true. I cannot understand why the department would have changed it. And perhaps we can just get the following answer together with the public comments, in the event that members need more information. But a direct response from Advocate Bell or the Secretary as to whether the Civilian Secretariat for Police provided advice to Cabinet that they should not amend that section with the introduction of Clause 4. Did they provide advice to the Minister or any other member of Cabinet or Cabinet as a whole that that section should not be amended and that it would be problematic constitutionally? I think we deserve that answer, because that is the crux of this matter. We absolutely need to clarify what level of interference, if there was any, existed in order to erode the last shred of independence contained in the Act as it stands currently. Thank you very much, Chair.
Thank you. Secretariat.
No, Chair.
Yes, Deputy Minister.
Thanks very much. I think where we are, Chair, in my comments, I spoke to challenges around Clause 4, and that the processes of the National Assembly through the committee allows that in the process of handling this the bill that we have submitted, the product that ultimately is going to be adopted, it will either be with amendment or without amendment, as outlined by the Parliamentary legal advice, which is correct. It doesn't mean that a bill submitted from the executive members must be tied in such that it can't be amended. There's no such a thing. The lawmaking processes, with what we have submitted to yourself now here, allows that you can engage in a process that at the tail end addresses all the concerns that have been raised, including the issues raised by the state law advisors. And I think that is what should guide the committee in deliberating around these issues, Chair. I think let me pause there. Thank you.
Thank you, Deputy Minister. Honorable Terplanch, followed by Honorable Golding.
Chairperson, thank you and good morning to everybody. Chairperson, I think we agree that this is a very important piece of, legislation. But I think at the moment we are confronted with a lot of questions, and I am not very confident that we are in the position right now to go ahead. My recommendation would be that, the answers that we tabled, that we get clarity on that, and, if necessary, that we arrange a next meeting, where we can get clarity on this outstanding issues, and then we will be in a position to decide on the desirability, considering all the issues that were raised. Chairperson, the fact that we are at this very late stage now is not the committee's fault. And we cannot be rushed and pushed into something because, the cabinet was, or rather Parliament was approached very late in the process. Thank you, Chairperson.
Thank you, Honorable Golding.
Thank you, Chairperson.
Yeah.
Thank you, Chairperson. I note that this is sent through rather late, and amendments have been made which were not requested, to my understanding. This is now left to the committee to fix. It has not been certified as constitutional. Surely somebody noted that prior to sending it to Parliament. It is now left to the committee to fix through whatever process it is. As indicated, there's both a monetary cost and a time cost on this. So, Chair, I would like to understand where that change came from. Honourable Whitfield was trying to clarify that, and I don't think that we received a proper answer. Why that section around the appointment was changed. We'd like clarity on that. I don't think it is the job of this committee to fix which is broken, which is sent to us broken. So if we can please get clarity from the Secretariat on that. Thank you, Chair.
Thank you. I'm going to give the Secretariat, but I want us to move towards developing a way forward. And I said in his input, the Deputy Minister and the officials from the Secretariat said they've been advised that what is presented to us would not pass the constitutional muster. Therefore, they are ready to concede and consider the advice of the State Law Office. As we debate, as we contribute, I want us to consider that. Secondly, that the Office of the State Law Advisor and the Parliamentary Legal Advisor, I also would appreciate if you can come in and advise us as to, in view of what the Deputy Minister and the Secretariat have submitted, how do we move forward? Because in the last meeting, and then Nico, from your side also, and from the side of the legal advisor, because there are those who are worried about timeframes. If we start the process now and do whatever, and we must make sure that we follow every legal process to the letter. What are the implications? After Mr. Amaru or your delegation, I would want those officers to advise us in that regard, because in his presentation, as he was making remarks, the Deputy Minister made a point which we cannot ignore. We must consider that there is a change of heart in this regard. Let's answer the question and we be advised in that context, please. Mr. Amaru, you can come in.
Thanks, Chairperson. I need to indicate that maybe there was a misunderstanding when Advocate Bell presented. So what she had said, or what she meant to say, was after we had already dealt with the bill, and in our consultations with the Office of the Chief State Law Advisor, so it came apparent to us that there are challenges with clause number 4, which they have advised us on how to handle that. And subsequent to that, we also went to seek also independent advice on the matter. And based on those, there is a position that Deputy Minister had indicated earlier on to say we have considered, and during the deliberations, that position will be advanced to make sure that the challenges that are there on clause number 4 are corrected. So our advice is we continue with the downstream processes, and once the matter or the deliberations are done on clause 4, then we will be able to advance the position that clearly conforms to the constitutionality as required by section 206 subsection 6 of the Constitution. Thanks, Chairperson.
Thank you, Mr. Amaru. Can I humbly invite the Office of the State Law Advisor and the Parliamentary Legal Advisors? Can you advise us as to, you had the inputs of members, you had the inputs of the department, the input of the ministry. We want to move forward. How do we move forward from here in terms of, if you can advise us?
Thank you, Chair. It's Mr. Pambradar speaking here. Chair, the committee would have to consider any proposals made by the department. And it's, of course, the prerogative of the committee whether to effect committee amendments to the bill, whatever may be proposed by the department. And I think perhaps the parliamentary advisor could perhaps provide advice in respect of the possible publication of such amendments for public comment. Thank you, Chair.
Thank you. Can we get from the parliamentary?
Thank you, Mr. Chair. I concur with Mr. Van Breda just on the matter that the committee can still consider these amendments. As articulated in our opinion, is that the committee can still consider the submissions that has been received to date, that will have been submitted, and also consider the opinions as well that have been received in regard to this amendment bill, and also in that process then effect further amendments where necessary to do so.
Okay. Honorable Groenewald.
Thank you, Chair. Chair, I think it's the first time ever in my parliamentary career that I get into a situation where a bill was sent to Cabinet. Cabinet was told that it is unconstitutional. They approve, they table it in Parliament, and they want to say to the Portfolio Committee, now you fix it. I'm very sorry, Chairperson. I can't think of any previous case of this. It is quite clear that the process was flawed from the start, where Cabinet approved and tabled this bill. But we must take this matter step by step. And we can look at all the legal opinions and everything. In terms of the procedures, we have to take now a decision today on the desirability of this bill, this flawed bill. Because we must say to each other, we have a flawed bill. It contains a clause and maybe other clauses, but specifically a clause for which is unconstitutional. And Chairperson, I can't think that any member of this committee can approve of the desirability of a flawed bill. We as members of Parliament, we have expectations. If the executive, if they put forward a bill, we have the right as members of Parliament to have the expectation that the executive must ensure that bills they present is constitutional. Chairperson, I've submitted 2 private members' bills into this committee. Each and every time it had to be approved by the legal advisors, specifically from Parliament in this case. And how can we as members of Parliament say that, yes, this bill is desirable? I would really formally ask Chairperson to put the question, and I will appeal to our colleagues and the members. We cannot accept the desirability of a flawed constitutional bill. And we can have a debate the whole day. Why are we here where we are? Yes, the rule says we can change. But Chairperson, what are we saying to the people of South Africa? Cabinet submits a bill which they know is unconstitutional, and now we must just fix it. I can't see that we can accept this bill, because we must remember this bill, which is in front of us. This bill is not desirable, and if we say it is not desirable, Chairperson, then there are other processes. Then the department, because it's coming from the department, it's coming from the executive, then they must go and do their work properly and come and submit a proper bill to Parliament, and for us as members of Parliament to make decisions on that bill. And that will be my proposal, Chairperson, as far as the desirability is concerned of this bill. Thank you.
Thank you, Honorable Whitfield. Okay. Mr. Breda.
Yes, thank you, Chair. I just omitted to add that before any possible or any proposed amendments to the bill may be considered, there has to be a vote in respect of the desirability of the bill, and that is in respect of Rule 2864, paragraph I of the NA rules. So before any amendments can be considered, there has to be the committee must consider a motion of desirability on the subject matter of the bill. So that's what I wanted to add. Thank you, Chief.
Thank you. Honorable Golding, followed by Honorable Gomba.
Thank you, Chair. Just following up on Mr. van Breda's statement there. This is a key juncture. Do we desire this bill in its current form? Not let us change it afterwards. So I did raise a question which I don't think was answered, and the Secretariat have put forward a bill where they've indicated they've received legal opinion. Can they explain when that legal opinion was received and why that was not included in the draft which went to Cabinet? Why have we been sent a broken bill? This is critical. This is critical. Can they please indicate why they've come after the fact, after it's gone through cabinet? What happened to that legal opinion? It was clearly not constitutional. It was clearly not. Their legal opinion seems to indicate that they need changes now. So why was it not fixed prior to being sent here? So I will agree with Dr. Groenewald and Honorable Whitfield that I don't think this bill is desirable. Can they please answer that? Thank you.
Thank you. I think you note that, Secretariat. Honorable Gomba.
Thank you very much, Honorable Chair, and greetings to the members of the Portfolio Committee and the advisors. Honorable Chair, I find the committee being in, let me say, in a state that is very difficult, but at the same time, we need to ask ourselves as a committee to say what is the function of the Parliament. We must start from there. The Parliament is supposed to be also doing laws and ensuring that they are also implemented. I find it very difficult, Honorable Chair, to find honorable members of the committee having a challenge of the wrong bill, which they are refusing for the bill to be corrected. To my understanding, there is a lot of an opportunity to amend the wrongs that we find in the bills. And the only way to do that is to refer it back to where it's supposed to be so that it can follow the correct channels and be corrected. And if it has to go to public participation, I would suggest that maybe, that's my input, maybe that can also go to public participation for communities to actually take part into the amendments of the bill. Honorable Chair, I find members of the committee commenting on the rejection of taking responsibility to amend the bill, not coming up with a plan on how to correct the mistakes that are found on the clause. I find Honorable Blunt having said to fix what is broken, we cannot do that. It's rejecting the responsibility of the Parliament. Also, I find the committee members also saying that Mr. Groenewald citing that the bill, the flawed bill, if and then also unconstitutional clause, those are the things that we are singing about which are wrong, which we need to correct as a portfolio committee to ensure that it is corrected through correct processes. Honorable Chair, I would like to move with the way forward that was proposed here by Mr. van Breder, who also advised, who also is an advisor of this committee with regards to that, to say that the committee would have to consider the advice by those advisors and then move forward to public participation so that this is corrected if it is not, if it has not gone there, because it's also raised as a matter of concern by some of the members of this committee that it could have not even passed that public participation process. So to correct what is wrong is supposed to be done by this committee and no one else, and it cannot correct itself. Even if you can try to do another bill, you will still have to remove this bill from the system, and it cannot just remove itself, but it will have to via the same committee. That's my input, Honorable Chair, to say let's take the advice, and I definitely support the advice of the legal people and the advisors who came forward here to give us advice to to ensure that the committee considers moving forward to correct this and also follow proper processes of public participation, and the bill must be amended. That's my move, Honorable Chair. Thank you very much.
Thank you, Honorable Gomba. I think we're moving towards the way forward. Honorable Whitfield. After Honorable Whitfield, Secretariat, you'll come in. And as you respond, please also indicate whether you've considered the submission from the public, whether those comments were incorporated into this submission, and then we'll develop a way forward. Honorable Whitfield.
Thank you very much, Chairperson. I just want to say that we either deal with the motion of desirability on the bill today, or we defer it to next week if members need to read through the documentation or receive any other advices. So I don't think that we need to, belabor the debate. I think people have made their inputs. I think comments and opinions have been put forward, facts and evidence have been tabled. And I would urge the committee to really think carefully about how we proceed, given Mr. Groenewold's comments about the uniqueness of the situation. And that we must remember that if the Chief State Law Advisor had certified the bill as constitutional, some members may still have found the bill undesirable, but then we could, of course, proceed to amend it. I mean, that's fine. We're in a situation where it has not been certified and we're being asked to amend it. I don't believe that there's been a change of heart by the department or cabinet, quite frankly. I believe that cabinet has been exposed and is now embarrassed and is now asking Parliament to fix their mistake. And we mustn't be ashamed about that. We must be able to say that. And it is our job to hold the executive accountable, not to do the rubber stamping and tidying up for the executive. It's not our job, Chairperson. Our job is to hold them accountable. And in this instance, to send a bill to Parliament that has not been certified is a slap in the face of Parliament and the people of South Africa. And we cannot allow this process to continue at an expense to the taxpayer, which may not even be concluded in the 6th Parliament, given the fact that we have 4 to 5 months of parliamentary term left in the 6th Parliament. So, Chair, we either put the motion or we defer it to next week. But that is the decision the committee needs to take. Thank you.
Okay. Let me allow Secretariat before we get into that. Thank you very much, Honorable Whitfield.
Chairperson, did you see my hand?
Oh, you have a new hand. Okay.
Yes.
Honorable Groenewald, sorry for that.
Thank you, Chair. I will be short. I refer to what Honorable Gomba has said, and she a couple of times referred to that we must follow the correct procedures. Can I just say, Chairperson, that's part of the problem. Rule 279 stipulates it quite clearly, because that's part of the procedure, that the Office of the State Law Advisors must, and I say must, certify the bill as constitutional. And that is the whole issue. If we follow the correct procedure, that is where one of the flaws are. Thank you.
Now, on that one, before Secretariat come in, because we might be having different understanding, can this Office of the State Law Advisor and the Parliamentary Legal Service come in just on what Honorable Groenewald said? Is it a must? I heard one saying is a procedural requirement, but if it's not certified, Parliament can still do 1, 2, 3. Can we be advised before? I don't want to lose it. Can we be advised before we give Secretariat? Office of the State Law Advisor and the Parliamentary Legal Service. Then we'll come to entertain the motion by Honorable Whitfield. Can we be advised?
Thank you, Chair. Mr. Van Breda here. Chair, in respect of the rules, sub-rule 3 of NA Rule 279, that provides that where a bill is not certified by the Chief State Law Advisor, the bill must be accompanied by a report or legal opinion by a State Law Advisor mentioned in sub-rule 2 on why it has not been certified. Chair, I can't add anything further to that in respect of the process. Just that the rules, your rules provide that if the bill is not certified, the bill must be accompanied by a legal opinion from our office. Perhaps the parliamentary advisor can add to that in respect of your processes and rules, Chair. Thank you.
Chairperson, sorry for interrupting you. Can we just get that Rule 279 on the screen again, please?
Right. Let's try to do that. Parliamentary Legal Service.
Chairperson, it's Siviwe Njigela now, not Bulelani anymore.
Okay.
Chair, and I think the State Law Advisor has put this quite nicely, that the procedure is that there must be a certification, right? But the fact that there is no certification does not prevent Parliament from considering a bill that has been put forward and make a decision on that. A motion for desirability is not so much dependent on the opinion on whether the bill is constitutional or not, is whether we require the law to be changed in a particular way. This is particularly important, Chairperson, in respect of this bill, because we are dealing here with a decision that was made by a court in terms of the independence of the IPID. So there is already a decision that we need to make changes to the law. And that is the directive of a court, which as Parliament, we need to see how we comply with that directive. So the issue between the State Law Advisor and what Parliament seeks to do now is really a question of how do we fix what is before Parliament now. To reject the bill completely when there is an order seems to create, in our view, a difficulty that may create a conflict between different arms of government. And I think that's what the committee needs to consider. If there is anything wrong in what is before the committee may want to consider how it amends that so that it is in line with what is required. Otherwise, we find, Chairperson, ourselves in a situation where two arms of government are going against each other instead of cooperating in terms of how they fix the problem that is facing the society. There is a need for the law to be changed, but how we change it is a different debate which must happen in the committee. But for the committee to close the door to that debate, it seems to us, and it's not really our place to say this, it seems to us it closes the door to a very critical debate. Everything could be wrong with this bill, but isn't the committee entitled to sit and consider how it can improve on this bill and make changes that are required to be done? So it seems to me the debate that the committee up to now has been engaging on is not so much a question of desirability or not. It's a question of substance of the bill. So I think in how we see it as legal services, there is a difference between desirability and the substance of what needs to be changed in the bill that is before you. But we seem to be engaging in the substance of the bill at an early stage of desirability. And I thought, Chairperson, we just needed to put that on the table for consideration for the members. Thank you, Chairperson.
Thank you. Honorable Groenewald requested that we flight. I'm trying to be patient so that we move together. Honorable Groenewald requested that we flight section. Can you say that again, Honorable Groenewald? Section.
Chairperson, I have it in front of me. It is Rule 279, Section 2, and it was referred now to subsection 3 as well. I have it, and we can have a debate on this. I think there are different meanings to see it. There it is. It says, a bill introduced by a cabinet member or deputy minister must be certified by the chief state law advisor or a state law advisor designated by him or her as being. Now remember, Mr. must be certified by the chief state law advisor as being consistent with the Constitution and properly drafted and so on. And then there's a reference to subsection 3. If a bill is not certified, as contemplated in Rule 2, the bill must be accompanied by a report or legal opinion by a state law advisor mentioned in Sub-Rule 2 on why it has not been so certified. Chairperson, this is a legal challenge. On the one hand, it says it must be certified and consistent with the Constitution. If it does not, it means if there's no report or if it is not consistent, then it says there must be a report, but it doesn't say that it can then just continue. It doesn't mean, as far as I'm concerned, and that's why I said we're going to get legal challenges in court on the procedural matters of this bill. And this one is going to be a contentious one, because there are different, there are different interpretations on this one specifically. Thank you, Chair.
Thanks very much. I'm going to put a motion, but let me allow Secretariat first to deal with those questions before we move forward.
Thanks, Chairperson. Maybe there are two questions. One is about the public comments. Yes, we have received and considered the public comments, and if required, we are in a position we're able to provide those comments today and indication of how we have implemented them in the bill. Then the question of when did we receive the legal opinion from the private counsel, we received it yesterday morning. Thanks.
Thanks very much. DM?
No, thanks. There was a comment that whether indeed there is commitment from the executive with regard to clause 4. So in order for it to be in line with to address the issues that the state law advisor raised, which they have explained here, that the problem is around clause 4. We are committed to that. I explained in the beginning that we have attended to the challenges around clause 4, which were the basis that the state law advisor said that they can't certify it in the manner in which it is because it does not talk to the independent. And of course, we were not happy with that explanation. That's why we then went further through the office of the state law advice to get an independent expert, constitutional expert on the matter. And it is on the basis of that we then discussed and then reaffirmed the views of the state law advice. But because we received it yesterday, if we had to do further to withdraw what we have submitted and submit that which we received yesterday, we found it's going to create problems administratively. And we said, when we come here today, as we introduce the bill, we will talk to the challenges around clause 4, and that we are amending it to be in line with the concerns raised by the state law advisor, because even the expert that we went out to assist us in this regard concurred with the state law advice. It's unfortunate that it took longer to receive for the appointment of that independent person and ultimately getting the opinion, to an extent that we're appearing before you this morning with that matter not having been filtered into the bill that you have before you. And I will urge that members should consider what is before you. We are committed to ensuring that the amendment is made and that Parliament, through the committee, will play a role in the appointment and the expulsion of the IPID, moving away from the previous arrangement that was there. And we think that it is within the committee jurisdiction to accept and process the matters before it. And I must say, Chair, that the issues of what the public submissions, we will provide them, but they are neither here nor there, because your process demand that you must consult, you must do public consultation. Whether it's the same people who come is immaterial, but it is in your hands to deal with that. And whatever input the public will come up with, it will, within your wisdom, you will integrate it. Of course, we will be part of the process with yourself up to the final process of you adopting the amendment with or without the bill, with or without amendment. But we will leave that in your hands. I thought I must just make this further elaboration, Chair, to assist the committee in terms of understanding where we come from. Thank you very much.
Thank you very much, Honorable Minister. Honorable members, I think in terms of our inputs, it shows that there's commitment to proceed with the bill, taking into consideration time constraints. And we have been advised by the legal people that it is the responsibility of this committee to amend wherever they want to amend, so that ultimately the bill satisfies the public out there and the Constitution. We were advised that before we can do anything we will need to deal with the motion of desirability. But there are still question marks here and there. I would therefore kindly submit to this committee that we deal with the motion of desirability in our next meeting, so that there be, where there's a need for consultation, there be proper consultation, because we agree, I think even the ministry, DM will agree with me that we don't want to offend any legal process which might lead us to any challenge. But there's commitment, it is a resolution of this committee, even in meetings before this one, that this is an important bill and we need to deal with it in a manner that satisfies the legal portfolio. So, and like I'm saying, I'm emphasizing, it is our responsibility as Parliament to make law and make sure that whichever we are not happy with, we amend, and therefore that's what we are going to do. But I'm going to submit humbly that we deal with the motion of desirability next week. At the same time, DM, if you don't mind, your office can submit the legal opinion that you were referring to. Thirdly, because we'll have this time, of course, the public comments, whether we receive them or not, is neither here or not there, but I would request that between now and the next meeting, which is next week, let's receive those public comments just for our own, just to empower ourselves. But we're going to deal with the bill, we're going to deal with the motion of desirability and move forward and engage in a process of amending whatever we amend. The office of the minister has made commitments that they are committed to the process, and so on and so on. And then from the side of our administration, Nicolette, you also come and give us a sense in terms of time frames, so that we are able to know in one way or the other as to, if we continue, how far will we go? Is that acceptable to members, that submission?
It is, Whip.
It is.
Yes, agreed.
Okay. If it is agreed, is there an opposing view? If there's no opposing view, let's have the motion of desirability dealt with in our next meeting. Let's have the DM, the legal opinion that you got from the senior counsel, and if possible, even the public comments, just to empower ourselves. Let's also have a view of the time frames if we were to continue with the bill. And I'm still repeating that I hear this commitment by members of this committee to proceed with the bill and make sure that the bill that we'll send to the Assembly is a constitutional, complies with the Constitution. Thanks very much. We're done with that item. What's the next item?
The next item, Chairperson, I think is closing.
It's closing.
Thank you, Honourable Seabi. It is indeed closure of the meeting.
Okay. Thanks very much for your time. I really appreciate your deliberations. To an extent, some of the deliberations are eye-openers. And thanks very much, the Office of the State Law Advisor, the Parliamentary Legal Service, Secretariat, Deputy Minister, Executive, Director, and your teams. Thanks very much, the parliamentary staff. Thanks very much for your time. Let's make sure that we prepare thoroughly for our next week's meeting. And we start with the issue of desirability of the bill so that we take it out of our way. Thanks very much. The meeting stands adjourned.
Thank you, Chair.
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 Thank you all.